All right. Rounding the bend here in the afternoon. I'm so excited for this next panel. Very grateful to pass the mic off to Professor Racehorse, Professor of Law here at the University of Colorado Law School. I'm very grateful for Professor Racehorse's leadership on this. So, Vanessa, please.
Hi, good afternoon, everyone. As an initial matter, I'd like to say thank you to Chris, Annie, and Daniel for all of the wonderful work that went into this symposium. A quick word of introduction. I'm Vanessa Racehorse. I'm a member of the Shoshone-Bannock tribes, as well as a descendant of the Cherokee Nation and the Shoshone-Paiute tribes. I'm also an associate professor of law here at Colorado Law, where I teach in the American Indian Law program, and I'll be moderating today's panel and keeping an eye out on the Slido, so please submit your questions along the way. Introducing our esteemed panelists today who will be leading the discussion, we have Professor Kekek Stark, Gussie Lord, and Professor Rebecca Tsosie. Professor Stark is the Davis-Johnston Associate Professor of Law at the University of Montana School of Law, where he serves as the director and faculty for the Indian Law Program and the Marjorie Hunter Brown Indian Law Clinic. Gussie Lord is the managing attorney of Earthjustice's Tribal Partnerships Program, where she represents tribes and indigenous communities in environmental litigation and advocacy. Professor Rebecca Tsosie is a Regents Professor and Morris K. Udall Professor of Law at the James E. Rogers College of Law at the University of Arizona, where she teaches in areas such as federal Indian law, property law, and constitutional law. Each panelist has a more in-depth description of their expertise and impressive experience in the online program, so please feel free to check that out. So I'm going to go ahead and start our discussion today with just some brief background on the land back movement and public lands, which our panelists will build off on a little bit more. So, as has been mentioned multiple times today, public lands in what is now the United States are the ancestral homelands of tribal nations. And federal conservation laws that were, say, originally designed to preserve areas for the American public, in their execution often involved the forcible removal and exclusion of tribal nations from lands that they had lived with and on since time immemorial. Now, in some cases, land was obtained legally, it was ceded via means like treaty, but in other cases, land was illegally seized. And all of that serves as a grave and enduring injustice, but tribes have not forgotten their connections to their ancestral homelands. Now, as one famous example that John Leshy actually acknowledged last night in his own lecture, in 1876, the United States government illegally seized from the Sioux Nation the Black Hills, a mountain range that traverses what is within now South Dakota and Wyoming, and it is the sacred heart of the Lakota universe that was guaranteed to them via treaty, and it's also since the time of illegal seizure where Mount Rushmore was carved out. Now, in the infamous 1980 case of United States v. Sioux Nation, the Supreme Court ruled in the Sioux Nation's favor, finding that the land had been, in fact, illegally seized, and stating that a more ripe and rank case of dishonorable dealings will never, in all probability, be found in our history. And they awarded the Sioux Nation money to compensate for the illegal seizure. But famously, they have not collected this monetary award because they want the land back, not the money. So the battle over the Black Hills is one of the longest standing, continuing legal and political fights over land in United States history. And it is a cornerstone emblematic piece of the land back movement. So while the panelists will go into more depth on exactly what the land back movement is and what it looks like, in very general terms, it's the movement to restore ancestral territory to its original stewards and to repair the historical damage that has been caused by centuries of dispossession. It's by no means a new movement, as many tribes have actually advocated for and organized for the return of their ancestral territory since the time of dispossession. And really, the first congressional land return can be traced back to over 50 years ago with the return of Blue Lake to Taos Pueblo. But, that was a watershed moment because the Pueblo spent over 60 years advocating for the return of their sacred Blue Lake. And it also achieved what many at that time thought was completely impossible, which was the return of federal land to a tribal nation. Now, to various degrees, the movement is experiencing some growing recognition, maybe some growing momentum. But it does, sorry, let me get some water. Poor timing. But it's also not only being seen at the federal level, it's being seen at the private level, as well as within state and local governments. It's also being incorporated to some degree within the global conservation movement. Some of you may be familiar with the 30 by 30 movement, which is a global commitment, formerly a national commitment, and in some areas a local governmental commitment to conserve 30% of lands and waters by 2030 in order to address the compounding dual crises of climate change and mass wildlife extinctions. So some governments, like California, are allocating actual money and making tangible commitments to restore land to tribes to meet these conservation commitments. And formerly, under the Biden-Harris administration, we also had the America the Beautiful initiative, which recognized the important role of Indigenous land stewardship. So this panel will go into further detail on the moral and the legal context for land back, conflicts and litigation that arise over public land management practices that conflict with or sometimes violate the rights of tribal nations, how land back has been and could be integrated into governmental policy, as well as the importance of Indigenous-led stewardship, including traditional ecological knowledge in land management practices. So with that, I'll go ahead and hand it over to Professor Kekek Stark.
Who's turned on the slides? All right. So as he turns on the slides, Buju, Kekek and go, Benasing Gwime, Biju and Dode, Mekanako Juing and Dujaba, Edash Nimigwitrin, my Ayanomano, Gigdoy, and Anishinaabe, not Cornegawin. So my name's Kekek. I'm Turtle Mountain Anishinaabe, or as the federal government would say, Turtle Mountain Chippewa. We're here to talk a little bit, set the stage on tribal land and what are those perspectives, how does that involve TEK, and then as we move forward in part of the land back. And so as we understand that tribal lands and our traditional territories, treaty territories, extend obviously beyond the reservations that we were left with today, that a lot of those lands are also federal lands and or state lands, and or private lands. And so as we begin to talk about land back and part of the policy, that's where we get these connections, whether tribes consider these lands to be sacred, special, or in all those aspects. So we begin by thinking about or recognizing that the Anglo worldview and tribal worldview were distinctively different with regard to our connection to the land and what we considered as part of that land ethic. And so we often begin with our creation stories. And so here you see a picture of our Anishinaabe flood story. As I was teasing Gussie earlier, anybody who read Turtle Talk this morning with the Enbridge briefing, they referenced the creation story and part of the flood story on why the Straits of Mackinac were sacred. But that connection, right, it creates our connection with our land through our creation stories, through our placement on this earth. And different tribes have different versions of their stories, whether they were placed there, whether they like emerged there, all those aspects. But really our stories typically reference our connection to the land and our responsibility and obligations that go with being on the land. And so often tribes considered the land to be a gift from the Creator to the people, and it created this interrelationship. And like for the Anishinaabe, our understanding of that relationship's embedded in our term for law. So our term for law is Ona Konegewin, and literally it means to reference the pipe ceremony. And so the idea of Ona Konege is pointing the pipe into the cardinal directions, acknowledging the parts of creation. And so that's embedded in our term for law. And the act reminds us that we are part of creation and we have to honor creation each and every day. So here's a picture of the pipe ceremony that tribes did during the Mille Lacs v. Minnesota case at the Supreme Court, acknowledging their law. So, for example, our term for law, Ona Konegewin, references the great laws of nature, right, as part of our creation story. And the notion is the law is for everyone, and everyone's ruled by it, including all things in creation, right? It's absolute law, has no mercy. It is a law that will always prevail, and the basis of the great law is peace and harmony, right? So before we can abide by the law, we have to understand our framework of the original instructions or the ordinances of creation. So that becomes important because as we were placed on this earth as part of our creation stories, we were given original instructions, and part of those that not only apply to the Anishinaabe people, but a number of tribes across Turtle Island all acknowledge what their initial original instructions were, and they're actually more similar as we go amongst tribes than they were different. But some of the nuances is all of creation had their own law and the freedom to exist, right? And we see that as part of the declarations with our rights of nature, whether it's the rights of Minoman with White Earth, the rights of Weaveroy with Yurok, the rights of salmon, or the rights of all other than human beings at Sault Ste. Marie, right? That's all acknowledging that right to exist. You also have the obligation to respect, preserve, and protect all those things that we were provided for. And we were stewards as relatives of all those aspects of creation. And that's important because we had kinship terms for the land in the same way that we have kinship terms for our extended relatives, right? So how we governed the land was parallel into how we governed each other and those relationships. And so that's why if we think about Mother Earth and Father Sky, right, we have these kinship relationships and how we treat our mother, how we treat our father, right? That's replicated in our interactions with the land and the earth. We also have the freedom of the people to use, right, the elements of life, air, fire, water, earth, and that includes the land, the natural resources, the beings on the land, the sacred sites. And we had to do that according to proper protocols of respect and offering. So if we think about our interactions with the land, a lot of times we had treaties, not only treaty with creation and treaty with the universe, that's recognized as the great law, but we had treaties with different species, treaties with the buffalo, treaties with the hoof nation, that laid out our obligations as to what were our responsibilities to each of those animals or beings, and so that's reflected. So here, part of the teaching talks about how the animals came forward when we were having a hard time, and they agreed to help us and provide for us so that we could live and understand our place in creation because we had lost our way, we weren't following the original instructions. So that's part of our clan system, and the origin of our clans comes from that treaty with the treaty with creation. So the essence of our original instructions is harmony, and you see that across Indian country and numerous communities all talks about harmony, balance. For us, the concept is mino bimata ziwin, or to live a good life. And you see that throughout. Here's an example of Nelson v. Yurok, where the Yurok tribe had a fishing rights case, and they acknowledged two fundamental rules of traditional Indian law. First, you had to respect the family, clan, and tribe. Second, you had to live in harmony with nature. And so here they noted that with regard to regulating a fishing right, because the individual member tried to be like, hey, you can't regulate me because it's my sacred obligation to go fish. And the court said, hey, part of regulation is to live in harmony with, and therefore we have the ability to apply our code. And so that becomes important, but acknowledgement of that harmony. So if we think about how we implement harmony, implement those principles, those instructions, a lot of times it's embedded in our traditional teachings, right? And those rights and responsibilities to the environment, to natural resources. And we see that now embedded in our traditional ecological knowledge, right? The culture and philosophy is incorporated with the science, but it's also incorporated as traditional tribal law. And so TEK, sometimes if we only leave TEK as potential science and knowledge, but not acknowledging its place as law, we're losing part of that element. So I always advocate that part of our law is embedded in those principles of TEK, and we need to acknowledge that. So some of the federal acknowledgements is the initial Farm Bill in 2008 had a prohibition on disclosure. So if a tribe shared sacred sites or sacred site information that wasn't available per the Freedom of Information Act, you could potentially keep it confidential. That extended then with the 2012 planning rule for the Forest Service. They acknowledged areas' importance and native knowledge in engaging in the planning process and planning documents. So another area where you could bring those traditional teachings and traditional law into the aspect. The EPA had a number of policies with regard to TEK, as well as your historic preservation. So here they said tribes had areas of special expertise, which means traditional knowledge in designating areas for protection. And interesting aspects, we think about your traditional cultural properties, and a lot of times they have to be like, oh, they have to be small and confined. I've always been an advocate that our entire treaty territory is a traditional cultural property, and we should actually assert it that way. A lot of times the feds want to say, no, that's too big, you can't do that. Or all of Lake Superior or all of Lake Huron should be considered a TCP, but that's for another conversation. Then you had the 2022 White House guidance acknowledging the duty or obligation to incorporate TEK within research policies and decision-making process. So when we think about land back, just to set the stage for my fellow panelists, sometimes land back means it's just this provocative expression, kind of as Professor Racehorse said. Other times it means the literal meaning, like give the land back. We also can think about it as, you know, equity into the future, right, as part of resource management, and the restoration of our relationships. So the key aspect when we think about land back, it's restoring our connections, right? Our connections based on our original instructions, our creation stories, expanding the use of our knowledge, increase capacity, right? So part of the capacity to manage land is actually having the expertise to do that if you're taking over our projects. So like in Montana, we had the restoration of the bison range to the CSKT tribe, and they had to build the tribal capacity to take that on. Co-management or co-stewardship, what does that mean? Big C versus little c, like co as an equal, which actually goes to consent, right? The consent of engaging in the practice, not just consultation, so moving beyond just talking to tribes, but actually getting their agreement and approval. And with that, I pass it on. And that was super fast.
I don't have a. Oh, we can turn the PowerPoint. Maybe I shouldn't have shut those all up. Oh, okay. All right, thanks, Kekek. Super interesting, and unfortunately, the federal land management agencies don't incorporate all those principles in federal land management decisions. And so I work at Earthjustice, an environmental litigation advocacy organization, and my team focuses on representation of tribes and indigenous communities. Our work is led by our clients and what the clients are seeing on the ground and what's happening to their rights and resources. And so in recent years, what that's meant for my team is a lot of litigation related to mining. As Professor Leshy talked about in his lecture yesterday, there was a huge rush for mining at the end of the 1800s and the beginning of the 1900s, and that sort of waned in some respects for various reasons. The high-grade ore bodies were mined out. Other countries started producing more minerals. We started developing stricter environmental regulations. And so there's been a little bit of a lapse or a lag in mining. It hasn't gone away entirely in the US, of course, but there's been an effort in recent years to push for a resurgence of mining and processing in the United States. Critical minerals are minerals that are defined by the US government as those that are needed for infrastructure or energy or defense, and there's a list put out by the USGS. I think Department of Energy also has a list. They keep expanding it, so it's a lot of different minerals that are critical, according to the federal government. And it so happens that a lot of those minerals are located, very near to tribal lands or on federal public lands where tribes have important resources, cultural resources, places of worship, specific plants, habitat for animals that are used by indigenous people or are special to indigenous people. And so when tribes have an issue with a project that's going to go forward, a big extractive project like a mine, there are certain rights that tribes have that are in addition to the rights that any citizen would have to weigh in on that project. So tribes have the right to consultation, government to government consultation, in which the tribe's rights are supposed to be, the tribe's position is supposed to be heard. The federal agency is supposed to let the tribe know what's happening, provide that information in a timely way, and provide a back and forth dialogue and incorporate tribes' concerns into those federal decisions, whether that's a permit for a mine, whether that's a grant or a tax credit, some sort of financial incentive for some of these companies. We believe that those are federal actions that are subject to consultation. And so a lot of times that doesn't happen or doesn't happen very well. So I'm just gonna run through a couple of examples of some of the big cases that have been going on in the past couple of years. And these are long cases. We could spend an hour on each one. I'm just going to hit a couple of high notes on each one just to give sort of a overview of some of the litigation hooks that our clients have and other folks. And I haven't been involved in all these cases, not by a long shot. So I'm not the best person to go over the ins and outs of some of these cases, but they're pretty interesting. And you'll heard of most of them. So the first one I want to talk about is Thacker Pass. It's a big lithium project in Nevada. That was the site of, or on and near a site of a massacre of Shoshone and Paiute people. And it was in 1865, and there were a number of massacres of these people to try to move them out of this area. So this one was particularly egregious. I'm not going to go into the details, but it's an area that the Shoshone and Paiute people have continued to visit. It was a site of a village. They used the plants there. They used it for hunting. And because of what happened there, it's a sacred space. It's a place of worship, a place of prayer. It's a place that they go to remember things that their ancestors endured. And so when this project came up, I think it's going to be 18,000 acres of BLM land. So it's just a huge project. It's going to be mining, going to be processing. There are going to be sulfuric acid plants, going to be a leaching project. So there are a lot of environmental concerns, but there's also cultural resource concerns for this area as a traditional cultural property, as somewhere that the whole area is important, not just one piece of it. So a lot of times when tribes say, you know what, this area is important to us, then the agency will say, okay, show us where the important parts are, and then we won't like touch that part. And that doesn't always work, because some of these areas are really huge. They haven't been fully, studied. They haven't been full archaeological and, cultural resource studies done on them. And the other piece is it's a landscape. There's a lot of pieces to it that fit together. It's the whole, feel and system that works together. So in the Thacker Pass litigation, I think there were maybe 6 impacted tribes. I think 5 actually came out, fully against it, and I think 3 entered into the litigation. And one of the things that was brought up was that this environmental review process was really fast. It happened in about a year. It happened during the height of COVID. The BLM's outreach efforts to these tribes, minimal at best. There were 3 letters sent out to 3 of the tribes, and so that was part of the argument in the litigation. This consultation was insufficient. You can read some of the cases, but it's a little bit, it's one of these situations where the courts say various things. Well, you should have done this, you should have done that, and you brought it too late. But ultimately, the litigation was unsuccessful, and that project's being built right now. So again, this is a lithium project. Some of the justification for that is for electrification, and so a lot of tribes support clean energy projects, but the truth is, if you've got an extractive industry next door, if you've got an extractive industry in your sacred places, what the minerals are ultimately used for is not necessarily going to assuage your concerns and assuage the impacts of the people who are affected. So that's the Thacker Pass case. Again, very, very broad strokes. Another one I'm sure you all have heard of is the Apache Stronghold litigation on Oak Flat. This one, also extremely egregious. This was Forest Service land, I believe, and this is a land exchange. So in the National Defense Authorization Act, I think back in 2014, this was added in a rider. Like, we're going to go ahead and give this land to Resolution Copper. They're going to give us some other land, and what's going to happen there is, if it goes forward, is a copper mine, and it's particularly bad because the way they're going to do it is they're going to cut out the copper underneath, and then the whole thing is going to collapse at some point in the future. I think they said it's going to be a 2-mile wide hole, 1,000 feet deep. And what's on top of this is Oak Flat, which is an area that has been used by the Apache for ceremony, coming of age ceremonies, healing ceremonies. It's acknowledged by everybody involved. It's a sacred place to the Apache, and that it's necessary to the practice of their religion. And so they brought this case against the U.S., saying that this land exchange violated the rights under the Religious Freedom Act and under the Free Exercise Clause. It's imposing an undue burden on the free exercise of their religion. Apparently destroying an area that is required for the practice of religion doesn't rise to the level of a government intrusion into their religious practices. Again, I'm not a RFRA expert, but if you read that case, it's pretty clearly egregious. And then the Supreme Court decided not to hear it. Justice Gorsuch's positions, that was worth reading on why the fact that they refused to hear that case. But there is another round of litigation going on. This is on a little bit more traditional environmental grounds, challenging the EIS as arbitrary and capricious. They did get a temporary injunction or preliminary injunction there, so that litigation's ongoing. It'll be interesting to see how that shakes out. And then some wins. We do get some wins. One case that we were involved with, Earthjustice was involved with, was on behalf of the Wallapai in Arizona. Again, a lithium exploration project. And what was egregious about this case is that BLM land surrounded the tribe's land on 3 sides, and in the middle of that was a tribe's spring, a sacred spring. And so the Wallapai argued that poking a whole bunch of holes in the ground around the spring could impact the spring. And BLM, in issuing the permit for that exploration, said, the area of potential effect under the National Historic Preservation Act doesn't include this area of land. And fortunately, the judge didn't buy it, and we got a first temporary restraining order, and then a preliminary injunction, and then the mining company pulled out of that project. So for now, we'll see what happens next. But that's where that is, and that was a great win for the Wallapai. And then the last case I want to touch on is the Shoshone-Bannock case. Shoshone-Bannock again versus BLM, and this is another land exchange, proposed land exchange, and maybe you can speak more about it, but there's a big phosphate plant that's been operating next to the Fort Hall Reservation for years, and they want more land to store the waste from that operation, the phosphogypsum stacks. And so this land that they wanted to exchange was originally part of the Fort Hall Reservation, and under the act where the Shoshone-Bannock ceded that land, it said you can only dispose of this land in certain situations or under certain laws, timber laws, mining laws, homestead laws. I think there were a couple other ones. And so BLM tried to dispose of this land under FLTMA. And what was interesting about this case is that the Ninth Circuit said, you know what, this is kind of ambiguous. Is FLTMA one of these laws or not? And they applied the canons of construction, construing ambiguity in favor of the Indians. And they said, well, no, this isn't one of those laws. And so this land exchange is invalid. So that was another good case that just came out this year. And so we do win sometimes. And then one other thing, just since I think I have time, because I talk kind of fast, is that sometimes there are fights, some of these big fights that you've heard of, Dakota Access Pipeline and Bridgeline 5 Pipeline. Some of those aren't necessarily on public lands, but they have a federal permit requirement. And so again, you have the consultation requirement, then HPA attaches, NEPA attaches. And so sometimes when you see tribes getting involved with those big infrastructure projects, even though it's maybe not on federal land, the requirement of a federal permit does trigger some of those federal obligations to tribes. So we're very busy, and probably more to come under this administration, but it's definitely good work, and happy to be here. Thanks.
Good afternoon. I am so pleased and honored to be here, and I want to thank the Getches Wilkinson Center for year after year, for so many years that I can't even remember, providing us with such a rich dialogue on the most pressing issues of the day with respect to all of the things that we care about in terms of our land, water, and natural resources. So Chris and Annie and your staff, you've done another wonderful job. And as a very, very junior professor, it was my honor to learn from Charles Wilkinson and David Getches and the legendary John Echohawk. Thank you for always being there to talk to us as though we were worth talking to, which I didn't know anything back in that time. And I learned so very much from all of you, so thank you. And now we have a brilliant young star, Vanessa Racehorse. Thank you so much. Vanessa has actually published on the issue of land back and did a beautiful article on climate justice and land back. And I want to save time for questions and answers from audience and dialogue. That was a wonderful project, and we've been hearing about the attack on the concept or even using the words climate change. And so your article has never been more timely and appreciated. So thank you. And for my co-panelists, it's an honor to join you. When Vanessa asked me to do this dialogue, I said yes immediately because it struck me that this was exactly the way to talk about land back. And Professor Stark centered the land within the knowledge systems of all of the nations of the land. And that is the original law. That law still exists because it's part of those places. And the way that it's honored and respected and carried forward by the contemporary tribal nations that represent those ancestors is an exercise of living memory, but embodied in the land and embodied in practice. And that is the only instance of that within this country that you will ever see, that ancient law being carried out. So when park managers or agency people say, well, you know, the tribe hasn't been here for a long time. That's actually not true. They are very much present. And I guess one of the most upsetting things about that executive order that Professor Krakoff so accurately described was unabashed commitment to continuing an exercise of erasure that I thought had been basically renounced in the most modern era. So we can't let that happen, and Professor Stark, you did a beautiful job of centering that knowledge in our discussion. And Gussie, Lord, thank you for your tireless work litigating on behalf of Native people and those lands. So if we think about Native relationships with what we now call those 600 million acres of public land, that's an example of fighting to preserve and protect the values embodied in the land and to make those histories, such as the event that you described in the Thatcher Pass case, evident to people. And I really commend you for that. And that is the spirit. And that's what the Native American Rights Fund has done tirelessly as well. So land back exists because of that steadfast commitment and fight to preserve and protect. So in my remarks today, I wanted to reflect a little bit in a way that would perhaps bring together some of the themes of the excellent lectures that we've heard. And Professor Leshy is a master in terms of describing the history and the law and everything that goes along with that. So Professor Racehorse gave me some questions to address, and those were very helpful to me. And I'm going to do that first as an exercise in the law, meaning the U.S. domestic law as it applies to land back. And then in the second part of my presentation, I want to reflect back to some of the themes, and I'm calling that the question of morality. And I don't like to de-link them, but oftentimes we have to do that in terms of getting people to be precise, for example, on what you mean by environmental justice. What do you mean by climate justice? What do you mean by restorative justice? What do you mean by reparative justice? What do you mean by epistemic injustice? I'll talk about all of those to some extent, but the law and morality are always in tandem there. So the issue in terms of a legal definition of land back, Professor Racehorse, you gave a nice, broad, holistic definition that I think is suitable for both law and morality. But in terms of the policy of land back, and thinking most recently of Dean and now Professor Kevin Washburn's paper on land back, he just wrote for the UCLA Law Journal. He actually wrote about over 100 years of land back from US federal policymakers to tribal nations. Some of them are notable and described in another article that Monty Mills and Martin Nye wrote. There were 44 of those kind of notable statutory transfers. Some of them are not notable in that instance, but they have been present ever since dispossession. Native people have been fighting in various ways and with some sense of victory. So he says land back is nothing new in federal policy. What is new and recent, and I tell my students who love land back, they love it, I tell them it's this generation that tied it to an indigenous-led social movement. And that is the restorative justice part, which is often tied to environmental justice, and in some ways it is, but is also very different than the types of environmental justice that go with citing noxious industries in minority communities, which happens all the time, and it always, in fact, did happen on reservation lands too. They're different forms of it. But that restorative justice framework is one that is devoted to healing, because what that seeks to do is to restore the relationship between the people and the place. in perpetuity. And there are different ways to do that. So the tangible transfer of federal public land to tribal nations is one, with all of the caveats that Professor Leshy talked about and that others have talked about. And yet it is true that most recently, I think 700 million acres have been transferred under those authorities to tribal nations. So that is definitely significant. The second part is what we have been describing, and Professor Stark talked about co-stewardship and co-management, and Professor Leshy alluded to that as being maybe more practical in some ways, at least in the near term, while you're getting that political will of the policymakers to happen. And that is really flourished in the recent era. And there was a joint secretarial order in 2021 between the Department of the Secretary of the Interior and the Secretary of Agriculture, really encouraging all of the agencies within those two very powerful bureaus to enter agreements and collaborative arrangements with tribal nations around this idea of stewardship. So that was an actual policy, followed by I think it was a 2022 agency kind of circular about ways in which those authorities could be marshaled under the existing laws and regulations. So there was a structure in law, but it was started with this kind of ethic of stewardship that we wanted to honor that. And if you look at the Department of Interior's, kind of mission statement during those years, it was powerfully related to climate, sustainability and climate and resilience and protection and restoration. And so this really fit with that methodology that you were going to work in tandem with tribal nations. The idea of co-management was, and none of these have a broad unitary definition, but co-management was linked to, efforts that had concrete legal authority behind it. So if the federal government delegated some measure of its authority and the tribe accepted that, and that would be a self-government compact to actually administer part of the federal program and get federal funding for it, that would be one instance. Or another would be where there was a shared ownership interest in a resource like salmon. So if the tribe had treaty rights on those lands, that would be a legal basis for co-management, which is a governance structure. And I think that, when we look at, for example, the Bears Ears and the Intertribal Commission there that has a place in that national monument legislation had ancestral ties there, that you're seeing some people express confusion over these terms of co-stewardship on an ethical basis and co-management as a legal authority. And so one of the things that I would encourage in Q&A as we get there, how much of that really is driven by a particular administration and its will or commitment to honor, because it's much easier to ignore an ethical commitment than a legal commitment. And I was thinking about the treaty rights as Professor Leshy talked about what is at stake in the new Gilded Age. I guess we would say that. Okay. I'm just saying that on behalf of myself, not my university, not anything like that. Okay. So those are kind of the mechanisms that we're working with. Everybody else was so good on time, and I just feel I don't want to go on too late, so I'm okay.
20 minutes.
Okay, Vanessa's being generous. So the last kind of part of the question was, what are the biggest challenges to land back? And this is going to lead me to the more holistic analysis. I think land back as a concept in the law is tied to a particular moment. So we've just come out of a moment where all of this made sense because we were trying to incentivize renewable energy and protect public lands and involve tribal nations in the administration of those lands in a way that was culturally appropriate and have those histories, displayed in the actual people who are still here today and navigating the cultural and ancestral landscapes. That's what the most recent moment was. That can be dismissed as ethical, moral commitments. And I am very concerned with the effort to rewrite the histories and the recent dialogue over, should there be medals of valor for those that participated in the Wounded Knee Massacre. That had me very troubled. We don't want to rewrite those histories. Those histories are very brutal. But that really is one reason that we have this panel today and the commitments that have been made. So it exists in a moment, but we cannot let that go with a rewriting of the history. There is a political will, and as I prepared for these remarks, I looked at I had a copy of the draft Department of Interior strategic plan that issued 4 strategic goals. Number 1, restore American prosperity, and that is tied to the production of American energy and letting America benefit economically from the development of natural resource. And I think everything that we've seen and heard, that truly is number 1 goal. Number 2, ensure national security through infrastructure and innovation. And that one also is on a fast track. And the discussion of critical minerals is definitely tied to the national security enterprise because that lets you bypass a lot of protective statutes just because of the emergency nature. And then the last 2, enjoy natural resources, the recreational use, and collaboration and coordination, including with American Indian, Alaska Native, and Native Hawaiian peoples, and that's what it actually says in there. Use the gold standard of scientific management, and we're gonna have fun with that one. So, okay, so that is exactly what is on the books now, and the question about the public trust that attaches to public lands and the Indian trust in terms of that relationship between federally recognized tribal nations and the US government has always been in tension, but the point today that we're at is that the system of federalism that we all grew up with, those of us who are teaching in law schools now, had the same understanding that there was a separation of powers, executive, legislative, judicial, the federal level, and then there was federal and state authorities. All of that is up for grabs right now. And the Supreme Court is doing a lot of major steps in dismantling some of the architecture of US constitutional federalism, in my view. So in my view, tribal nations cannot afford to believe that the trustee is always going to be there, or necessarily even that the state won't be there. And the state of California, in terms of its commitment to the 30-30 plan, and other states that are committed to those renewable energy portfolios and to just going ahead and saying, you know what, we're just going to deal with what is, that those are potential partners on many different levels, and they have been, you know, some of the most vocal in very recent months. So the other thing I want to point out was said by an earlier speaker in terms of self-determination. Self-determination is the overriding part of the law that governs the rights of Indigenous peoples globally. And that is autonomy. Autonomy to formulate a government, to have a position on territory and to negotiate with that government under conditions of equity for a full participatory role in the nation state within those collective identities as Indigenous peoples. That's the UN Declaration on the Rights of Indigenous Peoples. It can be expressed in a number of ways. The US sovereignty model is one, self-governance is one, collaborative management of shared resources is one, and participatory governance, and that is why voting rights and districting and all of that is so very important. That is another way to do that. So there are those powers that we have to participate within these larger discussions, and that has been a true value of this conference. Okay, so in the last 5 minutes, I'm going to sketch out some notions of what I mean by morality in the land back movement, the moral value of that. So the here I had to go back to work that I did really early in my career when I was looking at Indigenous land ethics and just what Professor Stark talked about. It was such a difference to see Indigenous land ethics and that form of relationality, kinship, respect, reciprocity, all of those things that are embedded in many Indigenous systems that don't allow you to overexploit natural resources. That was a shared ethic, and I think it is globally in many communities. But the ethic of opportunity that formed this nation, that formed the public lands, really was set on that utilitarian cost-benefit analysis. And that is the moment that we're in right now. The people who are for this fast-track energy exploitation, bypass all the protections, whittle NEPA down to the bare bones, that movement is designed to get as much economic value as possible in the shortest amount of time as possible. But what are the costs of that? And so I went back to a set of dialogues that I had in 1999. I participated in the New Millennium Conference at the University of Arizona. At that time, I was at ASU. And Stuart Udall was the keynote speaker. And he gave this incredible speech that was eventually, it was published. It's called Restoration and Conservation, the Importance of Perspective. And it was in the Arizona Law Review in 2000. But that was the turning point, right, from, you know, one century to another. What were we going to do? And he talked about the shortcomings that he witnessed as a congressman in the 1950s, and then working as you know, Interior Secretary for President Nixon and President Johnson and Kennedy. Yeah, so he was there for 6 years during those administrations. And he talked about the fact that, A, he couldn't even find Native people to serve in the solicitor positions. And so now, thanks to all of the developments that we've had, we have excellent Native attorneys. But he said, at that point in time, the decisions that were made were very short-sighted. They were just around getting the maximum gain in the minimum amount of time. And he talked about the things that he witnessed: dams, Colorado River Compact. The compact was in 1922, but it was in its full expression in the 1960s, right? That was the 1964 litigation, Arizona, California. And the uranium mining that was taking place under the auspices of the Atomic Energy Commission. He talked about how much power they had, and if you challenge anything, they just shut you down. And a lot of things happened behind the closed door. Well, he said, we're still dealing with the harms of that era. And he talked about what led to what we see right here and now, which is that the states still cannot agree on the distribution of the water from the Colorado River in a time of severe drought. And at that time in 1999, he said it's because they had carved up the river and they thought they owned it. Nobody thought about the river. Nobody thought about the watershed. They just thought about their ownership, and they were willing to dig in their heels. He talked about the contamination of uranium mines, and we still see that on the Navajo Nation. We see that in South Dakota and the Grants Mineral Belt, still affecting Native people on a health basis. There still is no national repository for nuclear waste, and yet there's an attempt to amp that up again for the data centers, which is the technology part of it, using the water, which is at a minimal flow right now. So we haven't learned the lessons that he encouraged us to have. And he said it is a question of perspective. And the values, I would say, are embedded in the land, and these are really my last remarks, that perspective. Do we center Indigenous peoples, as Professor Stark suggested, or do we just engage them? Because if we just engage them and do a minimal consultation, it really depends on the will of the agency or anybody to listen. The second, in terms of the objectives, what are the objectives? And land back, co-management, co-stewardship, they give us different options, but what is really at stake is the epistemic values that we are acknowledging. Do we want survival? Do we want health? Do we acknowledge that people are tied to the health of their environment? It's so laughable to me that the MAGA people like MAHA, make America healthy again. I like that too. But what goes into that is going to be a question of values. And so I think that that is the ethical commitment of land back. And climate change is real. And there isn't an energy emergency unless we give over all power and authority to corporations who want to make the most profit possible in the shortest time possible. But Native people are here from time immemorial into the future. And that really is that spiritual relationship that governs successive generations. And that's embodied in Article 25 of the UN Declaration. So Vanessa, thank you. I hope I haven't exceeded my time or your attention. Thank you so much.
Great. Thank you all for your wonderful remarks. So we have some great questions on Slido. We'll go ahead and start with the most popular one, which is from an Indigenous property perspective. The very existence of public land seems illegitimate in many cases. How do we address this in the land back context? And perhaps we'll start with Professor Stark.
Well, to me, it's interesting if you think about how, public lands is illegitimate, because really public lands is legitimate because the lands were provided for everyone, right? And even in the perspective of, in our treaties, when we said, hey, a lot of the oral history around the treaty time says, hey, we agree that you can live in our territory, but you actually have to live according to the laws embedded in the land. And so with that, part of the obligation for, the settlers and for the indigenous peoples was to live according to the land that the laws that govern that land. And so with that, the idea of it all being public land, our entire territories were public because it was to be shared in relationships among all of us. So I'd say an indigenous land ethic actually captures that concept, and we can bring that forward into a modern day context.
Wonderful. So that sort of lends itself or is related to another question for all of the panelists, which is, say, looking 50 years ahead, how do you think public land should evolve to balance recreation, conservation, and justice? Let's see, Gussie, would you like to start with some thoughts about this balancing act?
Sure. I think some of the other panels and panelists have talked about 30 by 30. I think there's a growing recognition that we do need to protect what public lands we have now, and the waters particularly. I'm worried about the water. And again, this long-term planning, this long-term thinking that seems to be absent in our political system. It feels like people, are just thinking about how can I maximize the profit or maximize, my political gain. And we really need to have comprehensive long-term land and resource management plans. I think you see some of the federal land management planning is 10 or 20 years. But it just always feels like really short-sighted if we're agreeing to, let a company go forward that we know is going to have a long-term negative impact on the aquifers, really dewatering out in the Southwest. I'm just really concerned about being able to understand the implications of our actions today. And so I feel like that's where Indigenous leadership is so important, and that's what we hear from our elders and our culture is always that you have to look out to the long term, you have to look for the future, and that we're borrowing it from our children, et cetera. And also, I can't remember who mentioned it, but our ancestors had the foresight of getting things written down. We've got these things, we got it in writing. So that's been helpful, even though at the time it seemed like these were these terrible cessions of all this land. But now some of those treaty rights are some of the things that we have that are our strongest arguments and strongest protections of land, including off-reservation land. So long way of thinking, or long way of saying we just need really long-term planning and really long-term efforts to understand how our actions are going to affect not only our children and grandchildren, but how is it going to affect the fish, the wildlife, the aquifers, the things that people are going to need 200, 300, 500 years.
Yeah. I completely agree with that. So I think that the public lands are vital. And I agree with the last question in terms of the idea of property and turning those relationships that were so carefully stewarded into property rights and then having it fought out between the federal government and the states and the private. There's something very insulting about that and not good, but it was good that they protected and preserved the landscapes that are attached to those public lands. And that's why people really want to go and use the lands for those recreational purposes that'll enable you to be in association with the resources that are so important, like the water. But there is a certain kind of mismatch because, for example, in the Oak Flat case, there's very little water in that aquifer, and that project is going to decimate it as well as collapsing the land, and that is going to affect all of the surrounding communities that are already suffering with the flood and all of that. So the landscape is inclusive of public lands and the lands adjacent, but if you don't protect the aquifers and the structure of the land, everybody is going to suffer. So I think that's another thing that people have to wake up to. I personally think that conservation and recreation and justice considerations can work together, but it has to be in that context of decision making that takes the values into account.
Yeah, and to add to that, if we think about some of those projects where, like, hey, a dam's removed, or like the highway's moved and we've removed a fill, like if we take humans out of the equation, a lot of times the earth can recover, right? So we're seeing these ecosystems drastically recovering as soon as we get out of the way as human beings. And so part of the idea is managing for the future is to manage our conduct as people and let the kind of earth, like we said, the earth has the right to exist. So let the earth do its thing and make sure we're not infringing upon its ability to do that. And so if we start to think about management in that way, it's really limiting each other as humans and letting the rest kind of do their thing. So interesting thing to think about as part of management.
Great, thank you all. So for the next question, how can non-natives respectfully support land back? Would anybody like to start? Maybe we can start at the end with Professor Tsosie.
So my students are always my teachers too, and they have a very robust theory of allyship, which they have managed to instill, and that's why I love to see the students coming together across student groups and interest areas, because it is this generation of student that encourages me, because they all want a healthy and livable environment for their kids and future generations, and they're at that age where they aren't afraid to imagine a better structure than the one that we've had. And the one that we are being presented with in our new Gilded Age, being a return to 1890 or whatever, like that should be unacceptable. And the students always see that, whether they're Native or non-Native, they respond to that. So I'm a firm believer in building those relationships across all of the communities that care about this, and internationally as well. I'm so happy to have one of our grad students sitting up there.
Yeah, I'll say that, you know, a lot of our efforts are not just involving Native clients. A lot of our most successful efforts have a lot of people involved that aren't Native people. I don't think you have to be Indigenous to understand what's happened in this country. To Native people, to not only Native people, but the history of this country. You can see it no matter, you know, who you are, or what your background is. You can see what's happening now, and you can see what needs to happen in the future. I think there's a lot of leadership in Indigenous communities, particularly the environmental space, but there's a lot of interest in learning, like, you know, you see it in the fire context, or, you know, the fisheries management context. Like, people want to learn how we can do things better. And I think, you know, there's been so many situations, you know, the Nature Conservancy, for example, they'll buy land and repatriate it to tribes. There's a lot of situations where Native and non-Native partnerships have been very successful, and I think that's certainly, you know, essential.
Yeah, and I think knowledge is important, and so as we talked about earlier, the lack of knowledge or rechanging our history is really problematic. And so the more we can share our information, share our stories, share why it's important, kind of as we said, like a lot of individuals have the feeling, right? They go to a place and they're like, ooh, something special here. I don't really know what it is, but I feel it. And tribes are like, well, that's because it's a sacred place. And so they're experiencing something that makes that happen. And the more they can understand it, then they can advocate, and then we can all work together and protect these systems. And a lot of, like, our elders say that it's important to not only like talk about or know it, but actually live that connection, live that understanding. And part of that's like involved in the whole aspect of the songs that attach to the land and the prayers that attach to the land and all those aspects. And I've seen it in meetings, like with the tribes, or meeting with the state or with the counties or with the feds. And when they open the meeting with the pipe and the drum and the prayer, it changes the entire tone and the entire relationship than if it's an adversarial and we're just going to sit down and argue. And part of that is being ingrained and embedded in living that connection, that spiritual connection. And so I think that's viable to the extent we can inform each other, then they can understand, like, this is the law that's applying to the land, and they can then be advocates and work together. And surprisingly, you're seeing it like in the Enbridge context, where you're having the state and the tribes together fighting against this corporation. And usually they're at odds with each other. And so the ability to build relationships moving forward is going to be really important.
Great, thank you. So can you please discuss how the narrative of keeping public lands in public hands can cut against or perhaps bolster the arguments for the land back movement?
Well, I would say, I mean, there is ways to protect it. So if we think about the bison range in Montana, right? It was given back to the tribes. It was agreed that it would be still open to the public, still managed in the same way it was now for educational purposes. And so there's ways to ensure public natures, public aspects. And just like now, as part of co-management, you know, tribes can take over numerous aspects of National Park Service processes and roles and duties and responsibilities. And so that can just be built in and made broader and engaged to, and part of the process to allow for that, right? So we had tribes saying, okay, can then, if they receive a parcel that they want to give land back, yet it has this restriction as a conservation easement, well, is that an encumbrance and therefore we can't take it into trust, and how do we address that? And so there's some of those questions that have to be asked and adhered to, but the process is happening. We're seeing tribes do that with the transfer of land, with the commitment to still manage it and utilize it in this public purpose and make it open. And so like, that's not necessarily a change as to whether it's feds as the manager, tribes as the manager, both as the managers, co-management, like it's being done and it can be done into the future.
Any additions?
Sure. So I think, I'm trying to remember the exact question. Yeah, tell me the question again.
Yeah, so how can the narrative of, keeping public lands in public hands cut against the land back movement or actually work to bolster the arguments for land back?
Yeah, well, some of the public lands, were taken in ways that weren't legal. And so I feel like that could be, cutting against it. There's still arguments that tribes certainly have claims to a lot of public lands, areas that weren't, issues that weren't fully resolved, things that weren't done in, the appropriate way, treaties that weren't fully honored, et cetera. So there's an argument that, there are certain areas that still belong to the tribes and should be returned to them. Keeping public lands open to everybody, I think, I think we all want to use it. I think that's why, you traditionally can see some partnerships between tribes and, for example, hunting and fishing groups that might be sometimes at odds with, other types of conservation groups. You can have those sort of shared interests. And the tribes wanted to, indigenous people wanted to keep the land open because they wanted to use it, don't want to just look at it. So I think certainly indigenous people understand that other people want to use the land for various purposes. What I think is important is just knowing, what you're doing and where. I think that's, that's the issue I see in a lot of our cases. It's like, this is a bad place to do, this specific thing. I mean, I feel like, as Americans, I feel like one of the basic things is like, you don't build stuff on Indian burial grounds. Like, haven't we learned that yet? It's a bad place for this activity. And so just knowing, where you can do things in an appropriate way, I think is really important.
Yeah, and the last thing I would add is that there's a whole discussion right now about democracy and about the principles that the United States supposedly embodies and are in the Constitution. I think that's what Professor Leshy was alluding to in that Article 4 placement of the property clause. I mean, that's really part of it. So that idea of collective ownership in the people and then having a set of processes that are responsive to the people. And if the people want renewable energy, and if the people are worried about climate change, and if the people don't want to be polluted, then the public lands being in that collective ownership are important, because if you parcel them out to private corporations, and even the lease rates in the 1872 Mining Act, I mean, that's giving away the public's valuable resource and then having somebody else get the economic stream. How is that benefiting the people? And so just at that level, I think we have to wonder about the relationship to democracy.
Wonderful, thank you all. So I'm gonna ask what will probably be the last question for the panel, but of course they'll be around afterwards. So are there any opportunities for making progress on land back or the federal government's use of traditional ecological knowledge under the current administration? And perhaps we could start with Kekek, since he gave us such a wonderful overview of TK.
Under the current administration, I think there's the potential to do things different, right? So like some of the barriers that have helped and or hindered Indian country, the land back. Like for an example, we had a tribe that the clinic is working with that because of the administration and their, like, there is no superintendent anymore in the community. And like, who's gonna sign my papers? Because the Constitution says superintendent has to check off these boxes. And so part of it was like, hey, can we delegate that responsibility to the tribal chairman? And the administration's kind of like, well, I'm not sure, I don't know, maybe, like, right? So something you would think that prior administrations like, no way, they can't do that. It's like, maybe you can. So maybe there's ways to be creative in how we do things different moving forward, right? So that's my hope for the future, I guess, analysis, to think like maybe we have opportunities to rework some of the things that are systematically have actually hindered our ability to engage in land back in some of these processes.
I'll just go down the road. Gussie, any thoughts, particularly as a litigator and somebody who's building alliances with a lot of non-natives and environmental nonprofits who are interested in land back?
Yeah, certainly. There's a conversation going on. What are the opportunities under this administration? What are the places where we can maybe clear away some problematic regulations for Indian country? If they are going to be disposing of public lands, like, are they going to be disposing of some of those public lands to tribes? And I think there's a lot of uncertainty right now, but I think there is certainly some curiosity about ways that we can still move our clients' interests forward in this administration and in this climate. I think we have to be careful, and I think we have to think through things carefully and again with a long-term lens. But certainly those conversations are happening. And as far as the litigation context and partnerships, I think people are open to thinking about other ways to move forward. We're losing a lot of our traditional environmental hooks under this administration, and some of the court cases and some of the changes to the environmental regulations. And some of the Indian law concepts and some of the tribal law efforts and tribal concepts might be, indigenous concepts might be, get more traction or be more successful. Wonderful. We'll have to wait and see.
So I think in terms of land back, that there's a real momentum around it, just coming out of the recent years where we've seen a number of kind of more public, for example, the Bison Range, like those are more public and really exemplify that history, but they also, each of them embodied narratives from way back about the tenacity of the people in relationship to that place and protecting it. So those are wonderful stories, and I love to listen to the people who are involved in those talk about them, and I think you learn so much. So, but right now, the administration is obviously downsizing the staff and doing other things that kind of cripple a lot of the efforts of the agencies. So one of the unfortunate consequences of that is it says, well, who's going to take over some of those responsibilities? And Professor Stark is correct that compact relationship, the federal government can compact with tribes, and that may be a way to actually steward those lands appropriately in this type of an atmosphere, and also instill that respect for the values in the land. Examples of TEK, because that was part of the White House memorandum and it hasn't been rescinded. I mean, I don't know if they're going to be exuberant about it or not, but there were a lot of very wonderful things that happened there. For example, around fire management, which is a huge problem right now in forest areas, which often are tribal, state, and federal. The resource extends, and that traditional knowledge about forests and fire management is pivotal. Same thing about fisheries and the quality of water, and also efforts to decontaminate where there have been release of toxins that impair a lot of landowners that are adjacent and using those waters. We've had some mine breaches and all kinds of things. So there's a lot that has happened that is positive, productive, and relationships have been created across those political jurisdictions.
Wonderful. Well, thank you all for your participation, and join me in thanking our wonderful panelists.